Hello, I'm Lindsay Altamirano, principal attorney and founder of Alta Legacy Law, where I focus on trusts and estates in California. So all of my videos are based on California law and jurisdiction. Today I'm going to talk about the difference between a will and a trust, because this is one of the most common questions I get. And it helps to understand a little bit more about what happens to your estate after you pass away. That will form the basis of the difference between a will and a trust. So when you pass away, your estate has to go through some sort of administration, almost like closing up a business. When we talk about your estate, we're just talking about everything you own, any debts that you owe, your life. If you don't have a will or a trust, your estate goes through probate court, and the probate code determines who's in charge of it and where all your stuff goes. If you have a will, it still goes through probate court, which is a big misconception. Wills do not avoid probate court. They do, however, allow you to determine who's in charge of administration and where your stuff is going to go. Finally, our final stop is a trust. A trust that is properly created and properly funded can avoid probate court, which means the administration takes place privately outside of the courtroom with no court involvement. So people like to avoid probate. That's typically where they lean. So they lean towards getting a trust. Another difference is that a trust allows for quite a bit more design, is what I like to call it. We have more choices. Maybe we don't want everything going to our kids at 25. Maybe we need to split it up into ages, half at 25, half at 30. A trust allows us to do that, and it allows a trustee to manage all of that after you pass away. A trust is also great when there is a time of incapacity, because then someone else can step up, the successor trustee, and manage anything that the trust owns without so much as a small pause to make that change from you to the successor trustee. This allows a lot of people a little bit more peace of mind to know that everything's going to be handled as far as it concerns the trust, should there be any incapacity during your lifetime. Another difference between a will and a trust also goes back to the whole probate administration. Because although a trust may seem more costly to create, a will is certainly more costly to administer. It also takes quite a bit more time to go through a probate administration than a trust administration. Typically, this is in the number of years that it takes to administer a probate versus a trust. It also costs more in attorney's fees and administrator fees than a pretty straightforward trust would cost to administer. And finally, if you do see that you may be reaching the estate tax limits, then trust planning will help avoid that, unlike a will. With advanced planning, we can create additional trusts, known as irrevocable trusts, to avoid estate taxes, which can be very high. But that also changes with the change in law, and something to keep your eye on as your trust continues throughout the years. I hope this video has been helpful. If you'd like to learn more, please look us up online at www.altalegacylaw.com. If you have questions about your specific situation and would like to schedule a complimentary consultation, please call us at 424-242-5021. We offer phone call or Zoom video call for all of our services to make it more convenient for you.